Hello everyone, good evening. This session was planned to discuss the very important judgment which has recently been pronounced by Supreme Court in respect with pre-import condition, that is in respect with advance authorization which is given to the importer to import duty-free products in India. Now that is governed through foreign trade policy and multiple custom exemptions, multiple amendments in the law in itself since the GST in place have been there. So we see the matter was not that simple to dealt with, but the way the judgment is being pronounced by Supreme Court is right or not, that we are not discussing here. We're discussing the way forward. Now the government will come up with a amendment in respective notification or not, whether they will be coming up with a circular which will be in the favor of SSC or not. That's all is anticipation. Today at place which we are where we are standing, now what should we do? That's something which we are here to discuss. Along with pre-import condition, we are going to discuss another important rule, that is rule 9610. I would say both the rules are kind of a brother and sister, but quite problematic sibling, because pre-import condition which put a restriction on the exemption on your IGST on your import basically. At the same time, rule 9610 works as a restriction on the refund which you receive on your exports. Yes, it's a double whammy on the exporter. At the same time, and in today's time when we are trying to boost our exporters, at the same time these judgment kind of put those exporters in a situation where they need to think about their business going concern. Or yes, I'm truly saying this because the kind of exporters which are stuck in this situation of pre-import and rule 9610 is a very worrisome and it should be a I would say prioritized issue for Ministry of Finance to think that whatever the decision they're going to take should benefit exporters at large. At the same time, I'm not saying that you should give away or take away all the exemptions, but there should be a way through which a problematic situation can be resolved. That's what the beauty of federal system. So we'll be discussing key points in today's a brief webinar, I would say, that is advanced authorization, pre-import condition, what it is about, rule 9610, and then how do you plan to handle your litigation, and what is the way forward in today's scenario. So what is advanced authorization? Before we go there, I just want to quote a very important quotation by Supreme Court, which is being quoted in the pre-import judgment also, that says that hardship is not relevant in pronouncing on the constitutional validity of a physical statute or economic law. Just keep that in your mind in case we have any doubt that hardship can be resolved at a Supreme Court level. It might not always. Now, what is advance authorization? It's kind of a licensing scheme, okay, which is given to a community importer and exporter. If a person is involved in manufacturing and if it is a merchant exporter, so if he needs to procure some material which he need to buy from outside India, now there are certain duties which are involved in that. Multiple components are there which are involved in that. So how do we get exemption of that? One way is to give a exemption notification through custom law, but there is a separate procedure also for doing it. That is, the government came up with a foreign trade policy, and then they came up with a law, or I would say a scheme in 1976 called as Duty Entitlement Exemption Certificate Scheme, which provided an entitlement for procuring duty-free products in India. So it gave the benefit of the basic custom duty, IGST, or any other safeguarding or any other additional duties which are levied on your imports. You'll be getting upfront exemption of all these duties. And then you can incorporate these products in the manufacturing process, and the ultimate product will be exported. The idea is to make India as a manufacturing hub, so that if a person is ultimately exporting the goods, so he should not be having any input tax credit with him or any sort of duty burden on him, in a way that taxes are not getting exported. That's what the idea is all about. That's why this advance authorization scheme was there. The name was different when it was introduced. The name which we pronounce advance authorization, it was named in September 2004 when the Foreign Trade Policy 2004-9 was effective. So the name was changed, intention was the same. Let's come to the present scenario. In 2017, when GST law was introduced, at that time there was no exemption of IGST which is levied on the imports in GST law. You must be aware, we should not touch upon the basics. I will just directly tell you what it is. Now, IGST which is levied on the import, whenever you import, you pay the IGST on your import. Under RCM mechanism, you claim the credit of the same. The levy of IGST is given to the custom laws. Through IGST Act, the levy is kind of transferred to Custom Tariff Act, through which it is being collected. Now, how this advance authorization exemption works. So there is only one notification, notification 18/2015, which speaks about BCD exemption and other duties which are levied on your imports. So how this IGST exemption work? Was there any exemption when the GST law came into picture on these imports which were made under advance authorization? The answer is no. There was no exemption which was available to these exporters. There was a trade circular, trade notice which was issued by DGFT in June 2017, which stated very clearly that whenever you are importing goods, you will have to pay the IGST on your imports. So it was very much clear. Okay, so IGST was supposed to be paid at that time. But it created a roadblock for exporters. Obviously, it impacts the cash flows, and impacted the cash flows, working capital, the interest costs, the banking cost altogether. So keeping in that mind, or keeping that agitation in mind, it was decided by GST Council that IGST exemption should also be given to these exporters. Likewise, a notification 17/9/2017 was issued, which extended the benefit of advance authorization to exempt from the levy of IGST as well. But certainly, the problem started from here when that notification came up with a condition. That condition was called as pre-import condition, and then it said that the goods must be physically exported. You must be hearing a concept of deemed export. In GST also, there is a separate section for that, which states that certain supplies will be treated as deemed exports. In DGFT policy, in foreign trade policy also, there is a separate chapter for deemed exports. So certain supplies which are not physical exports but to be treated as exports. So that thing was removed from this particular exemption. So your goods must be physically exported, and then it came up with a pre-import condition. I'll simply say that what is pre-import condition? Pre-import condition is wherein you import first, duty-free, then you export later on. Basically, government want you to use those goods in your exports, in your manufacturing, and then export the final product. That's what the pre-import condition meant. Now again, it was a problematic situation because this condition was not present anywhere before that period. Even before pre-GST regime also, it was not present. To say that it was not present for everyone would be wrong. It was present for few of the articles which are mentioned In the foreign trade policy, if we talk about para 4.13 of foreign trade policy, appendix 4J, which is given there for certain goods which faces the condition of pre-import when they import anything under advance authorization. At the same time, they have written in para 4.13 that government can bring pre-import condition for any goods per se. So it's very clear that they can bring condition, but at present it is being levied only on the appendix 4J, the products which are mentioned in appendix 4J. But after this condition was introduced, what happened? Certainly, certain exporters which were continuously in an import and export business, their imports were not counted, or they were told that you should be paying the IGST. You have violated the pre-import condition. If an exporter was having any domestic stock at that time, so what practice which was followed, that you was supposed, or I would say in previous regime as a normal practice, what exporters were doing, they were exporting first. If they are having any stock in hand, so they just took the advance authorization, and on the basis of the same, they were exporting the product. Where does this interpretation came from? This comes from para 4.27 of Handbook of Procedures of Foreign Trade Policy, which says that there can be exports in anticipation, wherein you just took the authorization number, advance authorization, and then you started the exports. You imported the product on a later stage. That was the normal practice, but this was stopped after this particular notification came into picture. Now, many petitions were filed when the department asked or put a question on petitioners, because when they went for closing of their license, when the licensing authority saw that you have not followed the pre-import condition, they did not close their license. For I would say redemption was rejected on this particular ground, and they were told to pay IGST. So matter started from there. At the same time, Directorate of Revenue of Intelligence (DRI) also issued multiple summons notices, I would say, in which this violation of this condition was highlighted, and accordingly importers or exporters were told to pay IGST, wherein they violated the pre-import condition. In the same year, Delhi High Court also came up with a very important judgment in Jindal Daicham, which says that if an exporter have completed the export obligation, irrespective of the pre-import condition, they have nullified that pre-import condition. They have allowed that if an exporter have completed their export obligation, let's close this license, redeem the license. But multiple case laws were pending before the High Court. Seeing that a lot of agitation is there, many export promotion councils filed representation that this particular condition is defeating the purpose of advance authorization. So government came up with another notification in 2019, which removed these conditions, the pre-import one and the physical export also, meaning thereby that pre-import condition was removed. Now it's a back to square one position, wherein you can export first and then import later on. That is the today's practice. So today, at present, if you say that pre-import condition is not there, pre-import condition was only prevalent during that interval period starting from 13th of October 2017 till January 10th of 2019. So that flight of pre-import condition violation is only for this particular period. So on 10th of January, through this notification, pre-import condition was removed, and the benefit of advance authorization was given to deemed exports also. Even if your exports are not getting physically exported, then also you'll be given the benefit of export obligation, fulfillment of export obligation for exports. It also came up with the condition of furnishing a bond. Okay, if the person have availed the input tax credit, they have paid the IGST, and a lot of procedural conditions were mentioned in that particular notification, which we are not going to discuss. But again, this was a good benefit which was given to the exporters. But I would say that that extra burden was removed. Now you would say that why there is a problem. The problem is that notification which came on January 2019, it came up with a prospective effect, not with a retrospective effect. And that was shocking for industry, because everyone was confused that whether that intervening period which we are talking about, for which the pre-import condition was prevalent at that time, whether I need to pay that IGST exemption back to the government or not, or at the same time when I have availed the benefit of refund on my of my imports, or like of my exports, refund on my exports. So whether it is allowed or not, whether I've violated the my license condition or not. So a chaos was again there. Accordingly, it led to a petition which was filed in Gujarat High Court. According to various observations highlighted by High Court, that pre-import condition was struck down. The court said it's arbitrary, it's not tenable in the law, it doesn't make any sense. So accordingly, that condition was struck down. At the same time, in another judgment by Madras High Court in the case of Vedanta, the condition was upheld. The validity was upheld. So we see that at that time two judgments were there. One was working in favor of assessee, one was working against the government. Accordingly, SLP was filed by the government before Supreme Court of India. And for that matter, Supreme Court allowed a stay on the judgment of Gujarat High Court till the time court would have heard the matter on merits. So that's how matter reached to the Supreme Court. Now the period for which we speaks about is the 13th of October 2017 till 10th of January 2019. You must be seeing on the screen that there is another date that we should be taking care of, that is related to Rule 9610. We'll discuss it later on. Before that, let's understand what is Rule 9610. That's another restriction which is given to the advance authorization holder. But it's not only for advance authorization holder, it is for other category of exporters also, which imports under EPCG. Those who procure the goods at a concessional rate, deemed exporters, and export-oriented units. So it is important to note that when this Rule 9610 was incorporated in the law through Notification 3/2018, which stated that a refund with payment of IGST will be restricted to these categories. That means if you have imported your raw material by availing the exemption of IGST, and if you fall under any of these categories, you cannot claim the refund of your unaccumulated credit by paying off IGST on your exports. You must be aware that exporter is eligible to encash their unaccumulated ITC as per section 16 of IGST. They have two options: either they claim it by filing a separate refund application as per Rule 89.4 or 4B, or they at the same time they have an option to file, or I would say they can get the refund by making payment of IGST, and after filing of shipping bill and GST or they will be automatically credited with the IGST payment amount. That's what the whole idea was all about. Now, at the same time, when we say that, where is the problem now? So this restriction of pre-import works on the import side, and this 9610 restriction works on the outward supply. Inward and outward both are restricted with some conditions. Condition is not absolute. Exemption which is given of IGST is not absolute. It comes with certain conditions, but both the condition, if we say it's a procedure and procedural in nature, I would say. Rationale was given for 9610 that government wishes to restrict a exporter who has availed the benefit of IGST exemption on their imports, doesn't encash their domestic ITC like that. Government itself kind of advertised their this with payment condition very widely when GST law was introduced. They said, our refunds have become seamless. At the same time, they are saying that, for a certain category of exporters, it will be restricted. I don't see any rationale behind it. There is no rationale behind it, that whether this condition is right or not. But this condition was there. Rule 9610 is still into picture. Pre-import condition is not into the picture. You need to understand that. The interplay we will be discussing. Now, timeline which is important in Rule 9610, that is from 1st of July 2017 till 23rd of October 2017, the Rule 9610 is not into picture. Then from 24th of October till 9th of October 2018, when this rule was not into picture, by the language which they have incorporated in the law was problematic in self. You can see a separate article. I will put that in the description box. You can read that why I'm stating these timelines. These are very important. So ultimately this rule came into picture, or I would say enacted, and to be followed only after 9th of October 2018 if we consider that this rule is fine. Why we are talking about timelines, we'll discuss that how these two conditions are interlinked and can be interlinked. Now, what does the Supreme Court judgment says, which recently came on the pre-import condition? Firstly, firstly discussed about the anomalies which were observed by Supreme Court while reading the High Court judgment. Supreme Court said that whether the DGFT has power to impose pre-import condition or not. So it read para 4.13 as mentioned by me, wherein it law clearly says that pre-import condition can be there and there is no problem in that. I'll share my screen also to show you that how this is being relevant and where it is written specifically. You see on your screen para 13, though this is of foreign trade policy 2023, but this has not been changed yet. In previous policy also this was same. So para 4.13 says that DGFT may by notification impose pre-import condition for inputs under this chapter. Second point is in imports items subject to pre-import condition are listed in Appendix 4J or will be as indicated in standard input output norms. So it clearly says that they can bring out any notification through which pre-import condition can be incorporated. Then I will show you the para 4.27, which speaks about the exports and deemed export supplies in anticipation or subsequent to issue an authorization, which says that you can import first and then export later on. So it gives an idea about that. Now, coming back to the discussion, what Supreme Court said that the government had a power to impose such condition. through these particular paras which are incorporated in the foreign trade policy. So we cannot say that it is arbitrary. At the same time, when we say that exemption was not there, it was very well made clear to exporters or importers that IGST is needed to be paid till the time that exemption notification was not there. That was also there through trade notice 11/2017. So there is no unclear situation. There was no unclear situation. Everything was clear. Through this notification also, it was made clear that this exemption is conditional and come up with the two conditions. Now the question is whether this pre-import condition is valid or not. We are not discussing that what is pre-import condition and what court said. The thing is pre-import, the court observed that whether pre-import condition is arbitrary or unreasonable per se or not. For that it made very important, or I would say to be remembered, remarks, and it quoted Rutash Kumar versus Om Prakash Sharma judgment, which says that hardship is not a ground for court to interpret the plain language of the statute differently to give relief. It said very clearly that even if it is bringing the hardship to the exporter, then also court cannot take a liberal view. And this line should be kept in mind for the pending litigation also, in respect with other provisions of the law in GST. So the judgment comes in line with VKC footwear judgment, wherein the court said that legislative power have power to impose certain conditions when it comes to refunds and exemption. Same attitude of court, honorable court, can be seen here as well. By seeing all these points, ultimately court said that this condition is fine. Government had very well power to introduce the same also. And that's how that Gujarat High Court judgment was reversed. Now what is the way forward? That is being stated in the paragraph 75 of the judgment, if you read, which says that what you need to do after this, after receiving this judgment, what you need to do. Now, as I mentioned that judgment's essence matches with the VKC footwear, you can see. I'll put a link of this presentation also in the description. This particular para is very much important when you read it, and read it when you think that there are multiple provisions of input tax credit are also pending in the court. So how Supreme Court might think from exemption or input tax credit point of view when we talk about this particular para. This is important. Now, how this pre-import condition works or aligns with Rule 9610. So as I mentioned, that timeline is very important. You need to understand that up to 23rd of October, Rule 9610 was not there. Up to 13th of October 2017, IGST exemption was not there. Everything started from October 2017 only. Now there is a common period which is colliding. What is that common period? The common period is when from 13th of October 2017 to 8th of October 2018, when pre-import condition was there, but Rule 9610 was not there. That means if you have violated the pre-import condition and if you have imported the goods with payment of IGST, there is no problem. Then from 9th of October 2018 till 10th of January 2019, this is a situation wherein pre-import condition was also there and this Rule 9610 was also there. I think I've misquoted it as a no on presentation. I will correct it. So in this period, both of the conditions were there. So this is a common period from 9th of October 2010 to 10th of January 2019. During this period, if you have violated this condition, pre-import conditions, you'll have to pay the IGST back. At the same time, if you pay the IGST exemption back to the government, your refund received with payment, which you were not allowed to do so, becomes regularized. Because Rule 9610 come up with a condition that if you have availed the exemption as per notification 79, then only you will be barred with getting refund with payment of IGST. But in this case, if you are paying that exemption back to the government again, so that restriction will not be there. So during this period, whatever the decision you have taken or will be taking, should be keeping this mind that, which is beneficial for you, but pre-import condition cannot be regularized on payment of your refund back. Both works differently. Rule 9610 can be regularized either on payment of your exemption or of your refund back to the government. At the same time, pre-import condition can be only regularized by making payment of your IGST back to the government. Both things are different. But by regularizing pre-import condition thing, your refund becomes regularized as per Rule 9610. That's how this common period and common alignment works. So you need to see which condition is allowed and is being practiced by your organization. Now, as I mentioned that this depends on the data, how the regularization way will be there. Now, if we talk about way forward, so what the judgment says? Judgment says a very problematic line, I would say, in para 75, where they say that, however, since the respondents were enjoying interim orders, now whomsoever was the party of this particular appeals, there was a bunch of appeals. It's not a judgment of only one party, there were other parties also. Right? Court judgment said that, however, respondents who were enjoying the interim orders, so that this judgment applies to only those respondents who were enjoying interim orders or to everyone. See, Supreme Court's order is a land of law. Law of the land, sorry. It applies to everyone. But the language which is mentioned by the Supreme Court is to be seen very carefully. That it said that since the respondents who were enjoying the interim orders till the impugned judgment were delivered, the revenue is directed to permit them to claim refund or input tax credit, whichever applicable or wherever custom duty was paid. For doing so, the respondent shall approach the jurisdictional commissioner and apply with documentary evidence within 6 weeks from the date of this judgment. The claim for refund or credit shall be examined on their merits on a case-to-case basis. For the sake of convenience, the revenue shall direct the appropriate procedure to be followed conveniently through a circular in this regard. So to simply put forward, what does it say? That you have 6 weeks of time. Let's start with that. The time period is 6 weeks. At the same time, what you will be doing in these 6 weeks, either if you belong to a council, export promotion council or any federation, approach to the government with a representation that you please change that notification, and you say that that notification is having a retrospective effect. Court has power to do that. Sorry, the government has power to do that. That is the first thing that you can do. Second is, if you think to regularize, how will you do it? Either you will be reassessing your bill of entries. Reassessment is possible or not when the goods are not with customs. Though there is a recent judgment in Sony India, which is affirmed and got stamped by the Supreme Court of India, which says that there is no time limit for making amendment in bill of entry. As per section 149, which empowers the custom officer to make amendment in custom documents, which doesn't come up with any time limit. So you approached your commissioner asking him to amend these bill of entries accordingly. Why this amendment is needed because this is not a demand payment. This is the IGST payment which you are making, and you are eligible to take credit also for the same. That's why the amendment in documentation is needed. Now, even though court have said that it applies to the respondent, so they have mentioned a wording like that, but everyone should do this exercise immediately. Then they should do the calculation also of pre-import violation. At the same time, they should do the calculation of 9610. What is the effect of both of these? Accordingly, the decision should be made. That's what I would say, whole idea of this pre-import condition, and 9610 can be regularized. So the future of 9610 also pending with various courts, and ultimately it will go to the Supreme Court also. But we're quite hopeful that that situation is a bit different when we talk about Rule 9610. So way forward, you can note it down. First thing is you prepare your data. You submit it with your counsel, respective counsel, who makes ultimately representation to the government that this much of stake is involved of our importer and exporter community, and how this rule is problematic to us. Thus, that pre-import condition notification should work or to be read retrospectively. Second thing is you prepare the data. At the same time, you approach a jurisdictional commissioner for making amendments in those documents, and start making the payment and take the credit of the same. Court have not said anything about interest. There is a Bombay High Court judgment in Mahindra Limited case wherein they say that IGST, so it's not related to IGST but related to other cess and other duties which are levied through some other acts in the custom law. And court said that there is no interest provision on these levies. Ultimately, IGST is also levied through a separate act through customs. To my humble opinion, this judgment should apply to that extent also, to the IGST levy also. So accordingly, there should not be any interest payment should be there. At the same time, when you're giving credit also of any payment, so the transaction is revenue neutral in nature. So there should not be any levy of interest. But this litigation depends on the fact-to-fact cases and the risk appetite also of any exporter, through which way he wishes to proceed. The same thing applies to Rule 9610 also. But you'll have to choose your battle wisely. And you'll have to make up your mind also through which way you're going to regularize this. Because if you're waiting, only waiting and doing nothing will not lead you anywhere, but can impact your business, because the way authorities sometimes take stand can shock you, either by freezing your bank accounts, by putting hold on your exports and imports. So it can have multiple implications. I'm just telling you what is the practical ground reality. Then it doesn't see that whether you are SME or a big corporate. When they take actions, they take actions. So that's all from my side. If you need any sort of help, or if you need to understand anything in the presentation, last but not least, I would pardon myself if I have quoted any notification wrongly. So that was not intention at all. The intention was just to discuss this issue with my peers, with all of you. Thank you so much.